The numbers seem to have slowed down, so it's probably a good time to start. Firstly, thank you everyone for joining us this morning on a webinar. We're still doing this remotely, and I suspect we'll continue to do so, more so for the convenience for everybody attending. The speakers, I hope, are known to you. I'm joined today by Nick Taylor, one of our junior tenants based out of Leeds, and we're going to be talking on the limitations on the unfair prejudice remedy. We've referenced particular 2 Court of Appeal cases, and Nick is also going to provide an update on some recent cases of relevance and interest. Can I ask that we do questions at the end using the question answer or chat function, whichever is your preference, and we'll try and monitor that. Also, this is being recorded today, and the recording will be made available. So if there's anyone in your office who's not been able to make today, they can have access to that. And also as well, don't worry about making any notes or anything, because we'll be circulating detailed handouts after the event. So I'm going to hand over to Nick now, and thank you very much, Nick. Off you go.
Thanks very much, Mark. And yes, good morning, everyone. And thank you for that introduction. As Mark said, this morning can be broadly split into 3 parts. Firstly, I'm going to summarise the factual background and procedural history of the 2 cases which this talk is focusing on, so Re Hut Group and Taylor Goodchild. Secondly, I will then briefly work through 5 other recent decisions of interest, all cases decided within the last year, which all concern the unfair prejudice remedy. That will not be a deep dive on any of them. More than anything, I'm just using them as a refresher of various key principles and examples of how the remedy is being applied at the moment. Those first 2 parts will then very much tee up the 3rd part, which is Mark's discussion of why the decisions in Re Hut Group and Taylor Goodchild are of such interest to practitioners in 2021, and what the takeaways are from those cases for Section 994 petitions going forwards. As Mark said, there are handouts which are both produced and will be circulated afterwards. Certainly for my part of the talk, those contain much more detail as to the facts of some of the cases which I'll be talking about. So without further ado, and hopefully you can all see my slideshow which I'm sharing. So Re Hut Group, this is a company which I'm sure many of you will have seen has been in the news quite a bit for the last few weeks, but for very different reasons. But in this case, factually, the petitioner it was a corporate entity, a minority shareholder, and it brought a petition making really 3 essential complaints in broad brush terms. So firstly, that the respondents, who were all mostly existing or former directors, had acted in bad faith or for improper purposes by issuing shares which proportionately diminish the petitioner's shareholding. Secondly, there were allegations of breach of shareholders' agreement, in particular failure to provide information to the petitioner. And thirdly, a removal of some what were called co-sale rights from classes of shares held by the petitioner. The petitioner essentially seeking an order for compensation paid both to the company and to it, and for a share issue to restore its shareholding in proportion. The respondents applied to strike out the petition essentially for the reasons which I've put on that slide there. At the first hearing, and again the citation is stated at the bottom of that slide, the strikeout application was wholly unsuccessful. Just to pick a couple of examples of the reasons, and again this is very much paraphrasing or summarising. The respondents had said that because the petitioner sought an order for payment of compensation to the company, that made it a derivative claim in disguise. The court said, well, no, because the petitioner is actually then seeking an order for the on-payment of that compensation to it, so it's not a derivative claim. Nor was it considered that there was any reflective loss. It held that actually the loss which is being alleged was in fact very much unique to the petitioner, as its shareholding had been affected almost in isolation by the proportionate reduction. That was not a company loss, it was a loss to it as a shareholder, so no derivative claim. That case was then appealed to the Court of Appeal and was partially successful on appeal. Mark will touch on this more in his part, but perhaps of particular interest to that part was the finding that the claim for breach of shareholders agreements may in fact be better split off as a separate Part 7 claim. that was a decision which has been left to the CMC of the case management. The paragraphs which are struck out were sort of struck out on the usual strikeout grounds, perhaps not of particular interest for today, but there is more detail in my handout. So the second case, or the second run of cases, which this talk is focusing on, is the case of Taylor Goodchild and Taylor. So the first citation there is to the underlying Section 994 proceedings where unfair prejudice was found. Arguably on the facts, it was fairly blatant stuff. Essentially, Mr. Taylor and Mr. Goodchild were solicitors who traded in partnership. They incorporated a company to take over the partnership trade. They were both directors and equal shareholders of that joint company. Relations deteriorated, as they so often do, and there was an agreement in principle to go separate ways. Mr. Taylor, and I stress at this point absolutely no relation to me, then formed a further company of which he was the sole director and shareholder. He then took work and client files from the jointly owned company and also instructed clients of the joint company to instruct his company. Crucially, all of this was done whilst he was still a director of the joint company. Probably unsurprisingly, unfair prejudice was found and a buyout order was made by the courts for Mr. Goodchild to purchase Mr. Taylor's shareholding in the joint company, as that was what had really always been intended. We pick up the case a few years later, where Mr. Goodchild brought later proceedings, essentially seeking payments for work in progress, an account of profits, and other monies still said to be owing to it by Mr. Taylor and his company. Mr. Taylor then applied for summary judgment on the basis that those claims should have actually been pursued in the original petition, and so were barred either res judicata, and so were an abuse of process, or were otherwise bound to fail. Now, that summary judgment application was successful before Mr. Justice Snowden, as he then was, but was appealed, and the appeal was successful. Again, Mark will discuss the outcome of that appeal later, but in essence, the Court of Appeal considered that even though the relief sought in these proceedings could have been pursued in the petition, that did not mean that it should have been, such that it was an abuse of process to then bring it in these proceedings. And the Court of Appeal went further and even considered that on the facts, it may have even been undesirable for those claims to have been brought, not least because they would have added time, cost, and other such matters to the original proceedings. So that's very much an overview of those two cases. But before handing over to Mark to pick up on those cases in more detail, I'm going to briefly run through 5 other recent decisions concerning the unfair prejudice remedy. Now, clearly, all cases turn on their facts, but I think Section 994 petitions particularly so. So I'm not going to run through the facts in any great detail, save to sort of highlight the key points. I've put those on the handout as well as a more detailed summary of the decisions. Instead, I'm going to focus on what I think is interesting about each case, or what the takeaway could be said to be. So the first case, Re or Marcom, German company. Factually, here there's essentially a corporate entity which had rights under the shareholders' agreement to appoint a director. It did so, it appointed a director, but its own director was then effectively excluded from management and governance. There were also unauthorized payments of remuneration and unauthorized disclosures of confidential information, in particular to the wrongdoing director's father, who was actually a retired businessman. I think there are 3 points of interest following and arising from this case. The first is that breakdowns of trust and confidence are oft discussed, particularly in the context of quasi-partnership cases. And this is a good example of a case where there was likely no quasi-partnership. Nevertheless, there was a shareholders agreement. The wrongdoing director had acted against those provisions, and that was enough to find and found unfair prejudice. So unfair prejudice was found, but the second point of interest is that there was no loss proved or really even alleged in the value of the petitioner's shareholding. And that was not really what the case turned on. So the third point of interest is that at the remedy stage, given that there was no proven financial loss, it was held that it would actually be disproportionate to make a buyout order of the petitioner's shares, even though that is what the petition had sought. Instead, what was ordered was an order made regulating the future conduct of the company and directors, which is the first on the list of the suggestions under the Section 996 remedy of the statute. It's true that buyout orders are often sought and are described there. They're often very desirable and appropriate to ensure a clean break, but here the judge considered that the proportionality requirements of Section 996 kicked in, and that the court, when making such orders it thinks fit, did not need to go that far in this case. So future regulation and of the conduct of the company was ordered. Second case is Il and Yesilkaya. The case is not picked for ease of pronunciation, clearly. This case was actually primarily brought as a petition for a winding up of the company on the just and equitable ground. So under Section 124 of the Insolvency Act 1986, but a Section 994 claim was also brought in the alternative for a buyout order. This was a quasi-partnership case, and indeed it was found here that there had been what the judge described as a catastrophic breakdown in trust and confidence. Now, I think this case is of interest really for three brief reasons. Firstly, it's confirmation that the just and equitable winding up is in principle an appropriate remedy to seek where there has been a breakdown in trust and confidence. Secondly, though, that was not ordered in this case, and the reasons why, well, arguably the clue is in the name of the remedy, because despite having a statutory footing, it is essentially an equitable remedy. And here the petitioner did not come to court with clean hands in the language of the well-known equitable maxim. In fact, the petitioner was arguably just as culpable in terms of the wrongful acts which led to the breakdown of trust and confidence. The judge, I think interestingly, also considered that the court would be concerned to avoid the potential stigma that would have attached to the wider successful corporate group following the winding up of a subsidiary. I think that's an interesting consideration, and clearly that potential stigma will not always save a group company. But on the facts of this case, it no doubt fortified the judge's conclusion here. The third case, so from a case where the petitioner did not have clean hands to one where the petitioner's hands were clean and the respondents really anything but, this was a particularly egregious example of unfairly prejudicial conduct. Essentially, two brothers befriended a couple in their 70s who were really retired and had experience of running care homes. All of the parties agreed to go into business together and leverage the couple's experience. And it was intended that essentially the brothers would be trained up in how to run a care home, and the older couple would step back over time. But what happened is that the brothers essentially created a corporate structure entirely against what was intended, such that the petitioners had no interest in the freehold of the care home. They were totally excluded from the management of the management company, and large sums of money were transferred from that company, which they were all shareholders in, to the brothers. The brothers actually traded the care home so poorly that a damning CQC report was issued and liquidators were ultimately appointed. The interest in this case comes really at the remedy stage, as what was ordered by the judge was expressly aimed at putting the petitioners in the position they would have been in absent the unfair prejudice. It's what I've described there as akin to an award of damages in contract for the expectation interest. Not exactly the same, but I think it's a useful parallel and perhaps guide. So for example, the valuations for the buyout order were very favourable to the petitioners. Essentially, the shares were valued on the basis of pre-wrongful conduct and transfers of money out. So I think it's an interesting example of how a remedy can be crafted under Section 996 to achieve justice given the situation. The petitioners even obtained an indemnity cost order against the respondents in this case because their conduct during the case, and particularly pre-trial, had been very serious and highly culpable. The fourth case, Faulkner and Bolin Holdings. This, I think, was a very interesting case, and I'm sure could actually probably warrant a talk of its own. I'll resist the temptation to go into too much detail, but what this case really emphasised is the importance of a company's what was called constitution. So here that was considered to be the Articles of Association and the shareholders' agreement in considering whether there had been unfair prejudice. Now that may seem like quite an obvious point, but interestingly in this case, the Constitution had been very carefully and deliberately designed to alter the balance of power as between the directors and the shareholders as what would ordinarily be the case under perhaps the common law or under statutes. Essentially, the company had been founded as a vehicle to pursue the technological ideas of a key director who was also the chief technology officer and on the board. That key director and another, who was the chairman, were under the Constitution intended to be given far more power than is usual and rights. The role of the shareholders, in the contrary, and also the majority rule was essentially depowered, not least by a requirement that they had to act in good faith, which was in the shareholders' agreement. So I think the takeaway from this is that conduct, for example, here, directors, who are the petitioning directors, being removed from the board under the usual statutory Companies Act 2006 powers and rights, can never be viewed in isolation as to whether it is unfair prejudice. So what at first blush may appear to be unfairly prejudicial or even not, actually when looked through the lens of the company's constitution, which might be particularly nuanced in any given case, may appear less so or more so. So a company's constitution is always key when considering unfair prejudice, and it really does repay careful analysis and scrutiny. I've used the final recent case here, Sprint Electric and Buyer's Dream, which is one of many cases involving these two entities when you search on Westlaw, essentially as a not so cunning way of shoehorning in a much older case, Re Southern Counties, which is a well-established authority when it comes to costs in Section 994 cases. So this was a cost decision. It was a cost decision following a successful 994 petition. The respondent attacked the cost decision, or both to some extent principle, but also quantum, on the basis that the petitioner had not been successful on all issues and not obtained exactly the remedy that had been sought. So the case itself is a reminder that judges can always take an issue-based approach to costs awards following trial, but that unfair prejudice petitions may be more prone to that line of attack, as they are often cases where wide-ranging allegations are made to get over the line of unfair prejudice, but some, and sometimes quite a few, may not always be successful, and also the remedy may not always be what was sought. For example, remember the first case, Maycom. The takeaway here is one of those which is, I think, easier said than done, because it's all well and good for me to say don't pursue issues that you're going to be unsuccessful on, which entirely relies on hindsight. And clearly it is far better to pursue enough issues to get over the line on Section 994 petitions. And it would be unwise to discard potentially meritorious issues because of future cost concerns. But I think it does act as a sounding note of caution about anything approaching a kitchen sink approach to issues. And more than anything, that may simply be of some help if you are faced with a disgruntled client whose instincts would be to pursue everything that has gone wrong in the course of a company's history. If there are some issues which are plainly unmeritorious and they may occupy significant time and resources at trial, it may be helpful to simply have this case in mind and to hand. As it was, the petition was actually awarded 65% of their costs at the liability stage and 80% at the quantum stage. So it was still quite a good recovery. So I hope those 5 cases may be of some interest to you. And as I say, there are more details in my accompanying handouts, but otherwise I will now hand back over to Mark, who will pick up on those first 2 cases. But thank you all.
Thank you very much, Nick. I'm just going to go on to making sure I can share my screen. Nick, I hope you can see my screen.
I can, yes.
Yeah, thank you. Just picking up on some things that Nick spoke about there, the MACOM decision, it's a case I acted for the petitioner on. It's actually very interesting in a number of respects. One, it was actually a petition by a majority shareholder. And as you'll be aware, there's nothing under section 994 which prevents a majority shareholder from presenting a petition. Usually a majority shareholder will not need to present a petition because they'll have the power to remove the wrongdoing parties. But in that case, those powers have been curtailed by the shareholders' agreement. I think MACOM is also a very useful decision for those who are acting for respondents, and to consider whether or not this is a case where if the unfair prejudice is established, your client wants to offer some terms of management order to regulate the affairs going forward to avoid the buyout order. Now, the guiding principle for a court is going to be, or should be, when considering whether or not a buyout order is appropriate or a management order is appropriate, is whether or not, to use the words of Miss Justice Briggs, as he then was in Sikorsky, are you going to be perpetuating a dysfunctional relationship? But I think there's a lot of merit for respondents, and it's a good cost pressure if they can say, well, actually, I know there's been these problems in the past. We don't think it needs the ultimate sanction of a buyout order. And if that is the respondent's case, they should be pleading that. So they'll give themselves some cost protection. I'm very grateful to Nick because he's done the hard task for me of really setting out the facts to the two authorities that I'm going to be considering. And what they concerned with is the discretion under section 996 of the Act. And we'll all be aware that that's been held to be wide enough to permit a petitioner who satisfied section 994 of the Act to vindicate claims that the company has arising out of the established grounds of unfair prejudice against the wrongdoing directors or third parties, provide that their respondent's petition. And what that would provide is it would enable that relief on those corporate claims to be ordered in the context of a 994 petition, as opposed to having going through the rigmarole of a derivative claim brought by the company. And the authorities in this area were Gamelstaden, decision of Lord Scott, Sikorsky and Sikorsky, Mr. Justice Briggs as he then was, and then Re Hut Group Ltd, decision of Mr. Justice Voss as he then was. So a very high powered judicial sanction for that approach. And you'll see in the handout that I also recommend in this area the very helpful review of the authorities by the senior registrar in London in the case of Woodliff and Rushton and Turner. Now, the guidance behind this approach was to enable the court to, in as far as possible, impose a clean break between divorcing shareholders, a sensible objective, you would say, bearing in mind the cost and time involved in shareholder disputes, the overriding objective, and the principle underlying the type of abuse of process explained in Johnson and Gallwood and Aldi Stores, namely that a party who comes before the court should be expected to bring all claims against the defendant at the same time, unless the court directs to the contrary. Now, what the Court of Appeal in the Hut Group and Taylor and Goodchild, without disputing the jurisdiction of the court to have corporate claims vindicated in a section 994 petition, they began to question the desirability of a petitioner so doing, and have sought to look at the circumstances in which it would be appropriate or inappropriate to vindicate corporate claims in a 994 petition. Now, in the Hut Group, which Nick's very kindly given you the facts to, the Court of Appeal was very keen to stress at the outset, it's still stuck by the fact that section 996 of the Act provides a, quote, wide and flexible remedy, but stressed that whether an order should be made under the section, and if so on what terms, was left to the discretion of the court. And it was stated that that power did include the power to order wrongdoing directors, i.e. directors who had breached duties that they owed the company, to pay compensation to the petitioner. Now, just pausing there, Mr. Justice, Lord Justice Voss, it was a member of this court, and he'd also been the judge in FI Core Limited. Now, in FI Core Limited, he had said that section 996 was wide enough to permit a court to order a wrongdoing director, respondent, to pay compensation to the company. The Court of Appeal here, the court of which he was a member, was saying it includes the power to order the wrongdoing directors to pay compensation to the petitioner. And it's not clear as whether or not that difference was appreciated and whether or not that reference was deliberate. At paragraphs 43 to 45 of the decision, the Court of Appeal agreed with His Honour Judge Eyre, now Mr Justice Eyre's reasons for finding that the petition was a true petition under section 994 of the Act, and not, as alleged by the respondents in that case, really a derivative claim disguised, in effect, a 994 petition, which should have been brought as a derivative claim. And the key point for the Court of Appeal was that whilst the petition alleged lots of breaches of statutory duty by the directors, i.e. the constituent elements of a corporate claim, it did not allege that the company, as opposed to the petitioner, had suffered any loss. And for the Court of Appeal, that was the key to make sure it wasn't considered as a sham petition. Now, they did reference the judgments of Lord Scott in Gamelstaden, but also his decision to the other end of the spectrum in Chime Corporation, all judgments in the Court of Final Appeal of Hong Kong. They said the Court of Appeal stressed that when considering whether or not a petition under section 994 is in substance a derivative claim, is highly sensitive to the precise circumstances of the case and the relief claimed. So there you are, reading the judgment, you think, well, that's very useful, thank you very much, we've got that. But then you'd be very disappointed because unfortunately, no guidance is given as to what the considerations should be when you consider these precise circumstances and the relief claim. What should you be looking for? And I'll bring this together in a moment. Nick also brought out the point that the Court of Appeal in that case expressed the view that whilst a claim based upon breaches of shareholders' agreement and for relief based upon breach of shareholders' agreement could be brought within 994 and enforced under section 996, they thought as a matter of case management, it might be better that they were pursued outside the petition by way of a Part 7 claim. But what they didn't comment upon, and I expect would be the sensible course, was as to whether or not it be appropriate for that Part 7 claim to be determined alongside the petition or following the petition. The approach of the Court of Appeal in the Hut Group was really to get back to basics and was to stress that sections 994 through to 6 are concerned with remedying the position of the unfairly prejudiced shareholder and therefore vindicating corporate claims that have caused the petitioner loss and not with claims that have caused the company loss, but not a separate loss to the petitioner. If it's the case that the corporate claims you're relying upon for the purpose of the petition have solely caused the company loss, then you should be looking to go down the derivative claim jurisdiction. Now, as I've said earlier, that approach is slightly difficult to square with the decision of Voss J as he then was in Apex, with the decision that he approved in the Hut Group, where he stated relief can be granted to remedy wrongs done to the company. Now, if that's correct, then that doesn't preclude you in the 994 jurisdiction from remedying wrongs done to the company by directing the wrongdoing respondent to provide compensation to the company. Now, this matter was taken further in the Taylor Goodchild Authority, where the Court of Appeal also considered the suitability of vindicating corporate claims. And this is in circumstances where it was found that the claim was an abuse of process, as it could and should have been brought and vindicated in the unfair prejudice proceedings, which preceded the same. And the consequence of it not being vindicated in those proceedings was the defendant to the claim in that case sold his shares to the claimant company, and he therefore lost an interest in 50% of the value of the claim, which the company, once it got input in the hands of Mr. Goodchild, sought to bring against the respondent. Now, just to pick up on a point which Nick said from the facts of the case, the Court of Appeal in that case was concerned with the desire of whether or not a claim could be brought in a 994 petition was one issue, as to whether or not it should be was another issue. But one of the very key factual issues in the Taylor Goodchild was this: it was quite clear at first instance when they were proceeding through section 994 that the parties and the valuer had tried to battle with what sum should be paid by the respondent shareholder to the company and to Mr. Goodchild in respect of the works and clients that he had taken away with him. Now, what the Court of Appeal said in that case was that, yes, it was being considered, but what the Court of Appeal said is if the parties had turned their minds to it and turned round to the judge and said, we've actually decided that it's not appropriate to vindicate this corporate claim now in this petition. What would the judge have done? And the Court of Appeal found that if the judge had been told of that in that situation, what he would have done was to say, well, actually, you can leave that for another time. I'm just concerned with remedying the position between the competing shareholders. If there's going to be a future corporate claim, that's for another time. But what the Court of Appeal did when considering this approach was they again endorsed the principles in Apex, but they did concentrate on the question as to when it would be appropriate for the court to grant relief in favour of the company in unfair prejudice proceedings. And they concluded, and this is the key part, that the court should only be minded to grant relief in favour of the company where the vindication of the claim and the consequential remedy would be straightforward, and there'll be no need to go beyond the issues to be considered on the petition, i.e. the tests of unfairness and prejudice. For example, if a respondent had said, well, if the company sued me on that corporate claim, I would raise arguments of limitation, or I would seek to rely upon section 1157 of the Act to excuse my conduct and my liability, then that would be a type of case where the court would say, well, the consideration of the court is going to go beyond the ambit of the tests of unfairness and prejudice, so that would not be appropriate to vindicate the corporate claim in the 994 petition. And Sikorsky and Sikorsky, a judgment of Mr. Justice Briggs then was this classic example of that case, where in that case, the petitioner didn't want a buyout order. He just wanted his brother, who was in charge of the company, to enforce the contract that they had entered into when they divided up the business, so that the company continued to receive funds, which would then be distributed to him by way of dividend. And in that case, Mr. Justice Briggs considered as to whether or not the respondent brother would have had any defences out with the test of unfairness and prejudice, for example, of limitation, before he decided whether or not it was appropriate to vindicate the corporate claim in the context of the petition. He said in that case, if he'd been of the view that the respondent did have the potential to raise arguments out with unfairness and prejudice, in that case, he was particularly concerned about an argument's limitation, then he wouldn't have considered it appropriate to vindicate the corporate claim in the 994 petition. What, however, Taylor Goodchild does show is this, and it is a warning for those of you who are going to be acting in cases where you're the respondent and you're going to, the order being asked against you is you're a wrongdoing respondent, but you're going to be asked to sell your shares in the company, because the consequence of that is you'll sell your shares in the company, and then the company will be in the control of your former shareholders, and they will then have on the face of it carte blanche to bring any claims, corporate claims against you based upon your period as a director. And what the Court of Appeal said in Taylor Goodchild, and where they did agree with as Justice Snowden, as he then was at first instance, was that if there is the possibility that there are going to be corporate claims pursued after the petition is dealt with, these do need to be spelled out to the court at the earliest opportunity, in effect in accordance with the Audi guidelines, so not only the court but the other parties know whether or not there's a risk of the claim in the future being challenged as an abusive process. There needs to be certainty either way. The claim in Taylor Goodchild, even though the Court of Appeal considered whether or not it would have been appropriate for it to have been considered, the Court of Appeal was very concerned that this claimant had not abided by the Audi guidelines, concerned that it had sat on its hands thinking, well, I'll get rid of this petition and then I'll sue the respondent, Mr. Taylor, when the company will just take 100% and he won't have a share of 50% of its value. The court said the thing which influenced the court in Taylor Goodchild not to strike out the case was the fact that the company agreed, as a matter of late concession, that it would limit its claim to 50% of the value, so the defendant was not prejudiced by not having had that claim vindicated at the same time as the petition. Now, moving forward, this is really the key factors, and again, these are set out in detail in the handout. Really, the guidance for when you're considering the petition is the approach of the Court of Appeal and Hut Group is that the parties and the courts need to get back to the purpose behind sections 994 to 6, and that is remedying the unfair prejudice in the conduct of the company's affairs by reference to the position of the shareholder. And as Nick said, by reference to his last authority, the parties and the court need to concentrate on those key disputes between the parties that will impact on the determination of the petition. The Court of Appeal is discouraging, in effect, kitchen sink petitions, and really realism needs to be applied in that if you are not going to succeed on allegations A, B, and C, really are allegations D, E, and F going to add anything to the position? A shareholder who wishes to vindicate corporate claims on behalf of the company, unless those claims are not going to go beyond the considerations of unfairness and prejudice, needs to have recourse to the statutory derivative claim scheme in Part 11 of the Act. Now, while Section 996 of the Act is still in the widest possible terms and does permit the court to make an order requiring a respondent to remedy a wrong done to the company, it will only be appropriate in those straightforward cases such as Sikorsky. Insofar as the court is going to be concerned with time and cost dealing with other issues, then it's not going to be appropriate to be dealt with in the context of the petition. And saving cases such as Sikorsky, the primary relief sought on a petition should be solely personal to the petition as a shareholder. If you receive a petition which is seeking relief in respect of wrongs done to the company, then the first thing you need to do is consider whether or not this is a sham petition and it is in substance a derivative claim and should be proceeding under Part 11 of the Act. If that is the conclusion, then you'll need to give thought to whether or not you apply to strike out. Obviously, what we mustn't lose sight of and what isn't impacted upon by these decisions is this. If a share purchase order is sought, then on the basis that the petitioner is the selling party, any valuation is always going to be on the basis that the unfair prejudice found in the case had not occurred. That's not vindicating a corporate claim against any respondent and ensuring the petitioner is not prejudiced by the conduct complained of. If the petitioner is seeking an order that the respondent, the wrongdoing respondent, sell their shares, then ordinarily the company will be valued as is. So subject to a minority discount, the petitioner pays no more than the shares are actually worth. Now, if you're in the position where you're acting for a respondent who has been found liable for conducting the affairs of the company in a manner which is unfair and prejudicial, but is ordered to sell their shares, then you really do need to be alive as the possibility of, after that petition has been determined, will the petitioner cause the company to bring a corporate claim against your client based on the claims made in the petition? And that's as per the position in Taylor Goodchild. Obviously, if that is the petition and you're able to compromise the matter before it gets to a trial, then any settlement agreement would be, you would achieve that by an appropriate release and satisfaction clause which bound the petitioner and the company with a consequential covenant on their part not to sue in respect to the matters complained of. If, however, there was no settlement and the court was proceeding to determine the matter, the position's far from clear as to how you're going to get that satisfaction to protect your client. The starting point would be there would be no compliance with the approach advocated about notifying the court at case management stage. So the court's proceeding not knowing as to whether or not a corporate claim is going to be brought in the future. Then I think the court has two options. The first is that when your client has been ordered to sell their shares to the petitioner, you would ask that the valuer, in valuing the value of the company, take account of any potential claims that the company might have as against your client for the purpose of fixing the price. So therefore, in effect, your client would be getting value for, in effect, 50% of any subsequent corporate claim which was brought against the company. I have problems with that route, but I'll come to those in a moment. The other alternative, and I think this is the much more clear-cut approach, is this, is to ask the court, under its wide discretion under 996, to make a direction analogous with that offered to and accepted by the Court of Appeal in Taylor Goodchild, that the company should not be permitted to proceed with any claim against the respondent after the determination of the unfair prejudice petition in respect to the matters complained of, unless that claim was limited to recovering a specific percentage of the value of the claim. As in Taylor Goodchild, it'd be limited to what the percentage value the petitioner would have been entitled to if he vindicated that claim in the context of the petition. I think in reality, that's likely to be the easiest position to achieve. I think valuing corporate claims that the company might have available to it will be fraught with difficulty, as it would be difficult to account for the costs that would be incurred by the company in bringing in force the claim, factoring risks that would impact on the success of the claim, and also the enforcement of any judgment. So really the lesson to take from this is, in particular for those of you who are acting for a wrongdoing respondent in circumstances where the relief being sought is that your client is ordered to sell their shares. In that case, you need to be very alive to what are the risks that your client facing in the future, the petitioner causing the company to bring further claims against them at a time when they will no longer be a shareholder and will therefore no longer have any interest in recovery in the share of the proceeds of that claim. As I said, there's a detailed handout that is very much a whistle-stop tour, as is only permitted by the time we have on these webinars. We're happy to take some questions now, and we're always available as and when, if anyone does have any issues which are arising out of this talk. I'm just going to come out of, I think we've got one question in the chat. Oh, sorry, the slides, I do apologize. I think the slides had frozen. I do apologize that I haven't picked that up there. They will come out as well to you on that one. If anyone does have any questions, we're happy to answer those now. Otherwise, we will be circulating the handouts and the slides after this.
Mark, could I just ask one question of you, perhaps, just as a
Yeah.
follow-up? If you are acting for a respondent or had acted for a respondent, and it is now essentially too late to be alive to the issues which you referred to in terms of potential future corporate claims, to what extent do you think the Taylor Goodchild Authority is really a very helpful authority, or an authority which could be relied upon to essentially get the 50% or whatever percentage limitation of any future corporate claims, if you're essentially having to do that on the hoof retrospectively now following that authority?
I think is the thing which bothered the Court of Appeal in the Taylor Goodchild was the fact that it could not direct a party to limit its claim out with the 996 jurisdictions 50%. It's something you would have to offer in that regard. Otherwise, you would be at risk of the Taylor Goodchild. I think one thing to be stressed on the Taylor Goodchild is it was very specific to its facts, and I think, but for the fact that the Court of Appeal tried to attribute blame to both sides, either should both have appreciated. They should have gone to the Vice Chancellor to have asked, how do you think we should deal with this case? Because we haven't been able to we wanted to vindicate it in the 994 petition. We haven't been able to vindicate it in the 994 petition. How do you think we should proceed for the future? Because the thing which really did bother Miss Justice Snowden at first instance, and I was acting for the applicant on that case, and we would say rightly, Miss Justice Snowden said was, well, you haven't complied with the Audi guidelines. You've sat on your hands, and really it's cards on the table approach when if you do intend to bring proceedings in the future, because it's not just the interest of the parties at stake, it's the interest of the court resources and administration.
Yeah.
We've got a question from Chris Charlesworth. So can you give an example where the court has made a management order? What is the best case to read? I think, Chris, on that one, Macom left it to the parties to come up with. Sikorsky's a good example of a management order as well. What it would be is what you've got to remember with a management order, it's going to be tailored to what has been the unfair prejudice which has been complained of. So if you've had breaches of a shareholders agreement, it would be a case that the management order would be directing the parties that they're to abide by specific clauses of an agreement. That would be the approach. My problem in management order is, in effect, you're in effect requiring parties to do what they're obliged to do anyway. And it does seem unfair that basically the party who hasn't been breaching with it suddenly becomes subject to such an order. Joel's asking in Macom, did we plead a management order as an alternative, or did the court get there on its own? No, we were acting for the petitioner in Macom. We wanted a buyout because we said it was a dysfunctional relationship which was being perpetuated, and it was the court in that case who said under section 996, we have a wide discretion. We're not limited to the relief that the parties seek. And the court decided in that case, we think the court was very influenced by the fact that it believed the respondent wouldn't be able to pay a management order, which is an irrelevant consideration. The court thought the parties needed one last chance because they were concerned that the breakdown in the relations had happened because of a third party who should not have been involved, and who the court directed should not be involved, and the fact that it happened very early on in the relationship. So those were the influencing factors for the court. But MACOM is a very good authority for reminding your clients that whatever the parties are seeking, the court can impose the order that it thinks is appropriate under section 996. The only exception to that is, absent a petition, the court cannot order a just and equitable winding up under section 996. It needs a petition seeking that relief. But I do think, I come back to this point, is if you're acting for a respondent, and especially a respondent who's thinking, I can't afford to pay out, or I don't want to pay out £2 million odd to the petition if this is acceptable, is thinking, well, can we in effect look at some middle ground of saying, well, I'm really sorry for what's gone on, can see how it's happened, we'll agree not to do it for the future. Because if you get in front of the right judge, that might be a very good tactic and good platform for moving forward. I think one thing just on that, there's recent authorities as well, is if you are a party in a just and equitable company, quasi-partnership, and there's uncertainty over the value, it's always giving some thought as well as to whether or not you do want to give the court the option of a just and equitable winding up, and whether or not instead of a cross, you want to issue at the same time that you issue your points of defence, you want to issue a just and equitable cross petition for winding up. Always something which needs to be considered. But I think the thing to take from this talk, unless you disagree, Nick, is really getting back to the purpose of section 994. It's there to remedy the unfair prejudice which has been complained of. And that's
I absolutely agree. I mean, I think that from my perspective, that's the way certainly at the much more junior end, that's the way you learn about the remedy. And then it's interesting to see how it can be applied in a sort of much more potentially wider ranging way. So I think Court of Appeal, putting it back to those first principles, certainly accords with that, and is entirely consistent with the statute, clearly.
I think the difficult one you're going to see on these is if you've got Sikorsky in a different situation where there was an agreement which the majority were refusing to enforce, and it means that you, as say the non-involved shareholder, are compromised by not receiving your dividends. Are the court going to expect you to go down the derivative claim route in that, or are they going to expect you to go down the 994 route? And I think what really, it's going to be interesting how the courts approach this at first instance. But I do think if you're acting for petition respondents, I think at case management conferences, being alive to this and saying, well, if you're not vindicating corporate claims here, what are your intentions as regards those in the future?
Yeah.
But no, again, with apologies to slides, I don't know what happened because they were moving on my screen, but seem to have frozen. Its technology has ganged up on that. But thank you to Laura for picking it up, but not apologies on our part for not picking it up when you raised it. Unless there's anything else, we'll conclude today's seminar. Thank you for your attendance. And if there's any issues which arise out of this talk or anything that we've provided by way of slides and handouts, you know where we are. Pick up the phone, and we'll look forward to seeing you hopefully in person next time. Thank you very much for attending.
Thank you very much, everyone. Thank you.
Thank you.
Thanks.